the erstwhile chair of this CPD, which is good because it means I don't have to do as much work as our speakers. The speakers are all drawn from the members of 9 Selborne Chambers, commercial chambers in Sydney, as I hope you all know. Our first speaker is Dean Elliott, who is one of our mid-seniority, I was going to say mid-rank, but he's first rank, mid-seniority juniors with a specialty in corporations law, but with a relatively general practice. He is going to speak about challenges for commercial landlords in the age of COVID-19. Now, just before Dean starts, can I remind everybody, we hope, have time for questions at the end. So if you have some questions that you want to ask, either wait to the end and then wave to attract my attention, or you can use the chat function which you'll find in the middle of your screen, down at the bottom of your screen, in the middle of the taskbar. You can certainly type something away, and I will communicate that at the end. But for the purposes of our sophistication with this technique, we're best with questions at the end. But thank you for coming. Let me turn over to our first speaker, Dean Elliott.
All right, thanks, Michelle. There was obviously a lot of media attention around what was going to happen to landlords, residential and commercial landlords during COVID-19. There's a lot of media attention about it, but I must admit, I didn't know really what exactly had been put in place until I was asked to advise on it. Now, recently I had a commercial landlord, obviously very upset that in his particular case, a lot of people weren't paying him rent at all, and he had about 10 tenancies in a building. And of course, he wanted to start proceedings to turf out all his tenants, and he wanted to know whether he could do that, or what impediments there were, or what processes he had to go through under the COVID environment. So I thought I would just address the two codes and regulations that you need to be aware of in the commercial context. The first is the National Cabinet Mandatory Code of Conduct, SME Commercial Leasing Principles, and that's a code which was approved by the National Cabinet on the 7th of April. And then there's also the Retail and Other Commercial Leases COVID-19 regulation. And that picks up in it the requirements of the code, because there's an obligation on landlords and tenants to negotiate in good faith. But I thought I'd quickly talk about what each of them require, and what you can do and what you cannot do. Now, the code itself is it's about an 8 or 9 page document which sets out a set of principles, and the objective is that the objective of the code is to share in a proportionate, measured manner the financial risk and cash flow impact during the COVID-19 period, while seeking to appropriately balance the interests of tenants and landlords. And when you go through and read it, you'll notice that it's heavily tenant focused as opposed to landlord focused. And the key parts of it is really in relation to the offering of rent waivers and rent deferrals that are proportionate to the reduction in earnings of the tenant or the subtenant. So in other words, if there's a downturn, there needs to be if there's been a downturn in turnover, that needs to be matched by a reduction and waiver in rent, and half of the reduction is by way of waiver, and then the other half is by way of deferral, which is then amortized over 24 months. And that's what the code envisages. It also envisages that if there's any benefits received by the landlord in terms of deferrals of loan payments, and that also needs to be passed on to the tenants, likewise with reductions in land tax, etc. But so those are the sort of the key elements of the code, and then the code is then picked up by the regulation which applies to retail leases and also to commercial leases. So the New South Wales regulation is in operation for 6 months. It's from 24 April 2020 until the 24th of October 2020, and after that date, the regulations are automatically repealed. And as I said, it applies to retail leases and also to commercial leases, and it applies to what's known as an impacted lease. And basically, an impacted lease is where the lessee qualifies for JobKeeper, and the main qualification to be part of the JobKeeper program is a 30% fall in turnover. That is the key condition precedent in having more than one eligible employee. So you've got an impacted lease if, as a lessee, your turnover reduces by 30% and your turnover is less than $50 million. And what that means is the regulations state that during the prescribed 6-month period, a lessor cannot take any prescribed action against the lessee on the basis of failure to pay rent, failure to pay outgoings, and not remaining open as a consequence of COVID-19. So the first key point to take from that is the prescribed action is all the normal things that a landlord would ordinarily want to do, where there's been a breach of a lease, for example, evicting of tenants, exercising a right of re-entry, forfeiture of the lease, drawing down on a security bond, terminating the lease, entering possession. Now, so those are the prescribed actions which are prevented during the prescribed period. And again, it's only as a consequence of those 3 matters: failure to pay rent, failure to pay outgoings, and not remaining open as a result of COVID. So therefore, if a tenant engages in other breaches of the lease, for example, they damage the premises, then the prescribed action is not prevented. So it's really honing in on financial consequences. Now, what the regulations also say is a prescribed action cannot be taken until the lessee has complied with the relevant clause in the regulations. And what that means is that before any of these actions can be taken, the landlord and the tenant must negotiate in good faith. Now, of course, that's not defined, but people generally know what that means. There's case law on it, and it's a relatively well-known concept. But the parties are required to negotiate having regard to the economic impacts of COVID-19, and also the leasing principles set out in the National Code of Conduct, which I mentioned before. So again, where provided they comply with JobKeeper, so there's been a 30% reduction, any reduction in turnover greater than that has to be met by the landlord by way of a rent waiver and deferral, which can then be amortized over a 24-month period. Now, in terms of negotiating in good faith, the regulations don't specify what information a landlord or a sub-landlord can, or a head tenant rather, can request from a tenant or a subtenant. Now, of course, it's natural that when complying in good faith, or when the parties are subject to a good faith obligation, they're going to need to supply such information to the landlord in order for the landlord to verify that there has been a reduction in the relevant income and any other information that the landlord reasonably requires in order to establish those matters. So that's the obligation to negotiate in good faith. If that does not occur, any disputes need to be referred to the Small Business Commissioner for mediation. And once that once there is a process involved in that, and then the idea behind that is a new rental figure will be agreed, and that should of course be documented between the parties. And then the Commissioner will give a certificate to the parties saying that they've engaged in this process. And then potentially, if there is then a subsequent breach of that revised agreement in relation to rent, then the prescribed action will not be prohibited under the code. I think those were the main points that I wanted to cover off on. Let me just have a look here. Yes, those are the main bits and pieces that I wanted to cover off on in relation to commercial tenants.
Thanks very much, Dean. They certainly are challenging times, and hopefully that précis will assist our dealing with these sorts of commercial problems. Our next speaker is Sam Sykes, also of 9 Selborne. Sam will speak about a recent case, Kirby and the Dental Council, and the implications of the decision in that case for professional conduct proceedings. Over to you, Sam.
Thanks, Michelle. Thanks, Dean. This is a matter that at its core deals with the question of apprehended bias in the context of disciplinary investigations, specifically within the context of the Health Practitioner Regulation national law, where it can have some universal application for legal practitioners. Some findings to keep in mind when considering the role of investigators in disciplinary proceedings, the extent of their powers, and how the court will consider their conduct in performing their investigation powers, and from the perspective of whether or not they are truly a decision maker such that the principles of apprehended bias apply. A common catch cry in most appeals to NCAT and beyond that somebody has been denied procedural fairness, and this was no different. The circumstances were as follows. In July 2015, a dentist, Dr. Green, was informed by a patient that the patient had been treated by Dr. Kirby for skin cancer with a product of dubious provenance called Cancerma. Dr. Green consulted a member of the Dental Council, namely Dr. Bill O'Reilly, for advice about what, if anything, Dr. Green should do, and was advised, quite importantly for what happened in the decision in the Court of Appeal, to refer the matter to the HCCC, which is the Healthcare Complaints Commission. In short compass, and I'll get to the facts in a bit more detail in a moment, Dr. Kirby denied that he treated the patient or had done anything untoward. Following the disciplinary or the investigatory procedures in the national law, Dr. Kirby was firstly suspended and then on appeal subsequently had conditions applied to his registration. He then went on, Dr. Kirby then went on to appeal the decision, saying that he was not afforded procedural fairness by the decision makers when they suspended and then placed conditions on his registration, because the first instance decision makers in his submission were also the people who made the people who conducted the investigation work were also the people who made the ultimate decision to suspend and then place conditions on his registration. I'll try and keep the legislative background to it short because of the limited time we have. But firstly, there is a requirement under the national law that a practitioner report what's called notifiable conduct to the Healthcare Complaints Commission. And notifiable conduct is anything that a practitioner considers their colleague is doing that might cause a risk to the public safety. As the Court of Appeal made clear, once that process is undertaken, the national law requires that action be taken regardless of the terms of the complaint. Section 150 of the national law then requires the Dental Council, in circumstances where it's required to do so, to suspend the registration or otherwise impose conditions upon the impugned practitioner's registration. If a decision is made that conditions are to be imposed or that the registration is to be suspended, the Dental Council then must refer the matter to the Healthcare Complaints Commission within 7 days of the order. That's significant because the summary of the process is that the Dental Council is the first point of contact. It undertakes what it considers to be a preliminary investigation. There is a hearing by the Dental Council if necessary, but it's not a formal oral hearing as you would expect. There's only written submissions, no cross-examination and no true evidence. Before if a decision is made, it's then transferred or referred off to the Healthcare Complaints Commission. It was described by Justice Barrett in the Supreme Court as being essentially interlocutory in nature, which was a decision and a point that the Court of Appeal agreed with. So the investigation of the complaint for the Section 150 decision, there were 4 members of the Complaints Committee appointed by the Dental Council. They determined that they should inspect Dr. Kirby's records and then upon the inspection determine whether or not there was adequate evidence to make a finding against him for the purpose of Section 150. During the inspection, they found a reference to the impugned drug Cancerma that caused them some concern and indicated that further investigation was required. 8 delegates of the council indicated that a hearing was necessary. Dr. Kirby requested an adjournment on the basis that he had surgery booked under general anaesthetic the day that the hearing was scheduled. The adjournment request was denied. Dr. Kirby at that stage failed to engage in the process, so an order was made suspending his registration. Dr. Kirby then appealed that decision using the mechanisms under the national law, and the suspension was lifted and new conditions were imposed. The written reasons essentially found that there was a risk posed for safety. They were concerned about his pattern of behaviour, and it was ultimately referred to the ACCC to be dealt with as a complaint for investigation. NCAT is the jurisdiction to appeal the Section 150A decision, which Dr. Kirby undertook. NCAT dismissed the appeal on the basis that what's referred to as the double might test in Ebner and official trustees in bankruptcy, a High Court authority on apprehended bias, was not met. The crux of the argument put by Dr. Kirby from the early stages of the NCAT hearing all the way through to the Court of Appeal was that the delegates, such as Dr. O'Reilly and the others who sat on the Dental Council investigation committee, ought not have acted as decision makers when they had been involved in the investigation. Justice Barrett determined that there was no denial of procedural fairness. And I won't go in too much detail to what he said, purely because Justice Brereton gave a very useful summary of those findings and agreed with them. The 2 points on appeal were that the trial judge erred in law in applying the wrong test for reasonable apprehension of bias in circumstances in which all the members of the Dental Council charged with making the decisions had prior involvement in the investigation of a complaint. And secondly, the trial judge erred in the application of law in finding there was no reasonable apprehension of bias. In other words, the two findings were wrong test, and then wrong conclusion. The apprehended bias test, the three areas of bias that were alleged were firstly that Dr. O'Reilly had advised Dr. Green to notify the HCCC of his concerns about Dr. Kirby's use of the drug. The three delegates participated in the decision that Dr. Kirby's practice be inspected for matters unrelated to Dr. Green's complaint, namely infection control. Furthermore, all three of the delegates had participated in the council's decision that it should consider exercising its powers under Section 50. In doing so, they received reports of a Dr. White and various other representations about the course the council should take. And it was submitted that because those three investigatory powers were used by the delegates, they ought not to have been responsible for making the decision to suspend or cancel the registration. The apprehended bias test is where this, I should note as well that the court, this was an interlocutory matter on an area of law, and the Court of Appeal found it of such significance that leave should be granted to hear it, purely because it dealt with some fairly novel elements of apprehended bias in the context of disciplinary proceedings, and where it draws the line between what's an investigatory process and what's a prosecution. Now, the test that was adopted by the Court of Appeal talks about two species of apprehended bias. The first being prejudgment bias, which I think speaks for itself, namely that the decision maker who's going to ultimately hear and make a decision has come to the final hearing with their mind made up. The second more significant significant species in the context of this hearing was that of prior interest bias, which is, for example, a financial interest in the outcome of the hearing, or, as was the case in this, where it's alleged that the ultimate decision maker was, in the first instance, the prosecutor. That type of bias being said to be born out of the natural human inclination to wish to see one's own position prevail, and that invests the proponent with a form of ownership for the purpose of the principle that nobody should be a judge in their own cause. And I think most members of the bar would agree that there is an interest born of their inclination to see their own position prevail. Where it was alleged that this arose, as I said, was in the various delegates being akin to that of a prosecutor, taking the reins from the time that the complaint was made right up until the inspection and the ultimate Section 150 hearing. The general points that fall from it, I'm mindful of the time. Firstly, the circumstances have to be considered as a whole rather than as the individual components of comprising the allegations. So it's not enough simply to look at the three individual pieces of conduct to determine whether or not, in this instance, the delegates weren't able to bring an unbiased mind, but to look at the entirety of the circumstances. That includes the factual circumstances and the statutory context. The Court of Appeal emphasised the statutory context on the basis that, firstly, the purpose is for public protection, which gives the Dental Council fairly broad and unfettered power. And the second was the wording that they must take action if they deem it necessary. So once they reach a decision that some sort of investigation is required, then they must suspend, cancel, or otherwise place conditions on somebody's registration. What fell from the Court of Appeal was agreement with Justice Barrett's findings, in particular that the delegates had not reached a concluded position or contended for a particular outcome in the course of their investigation. Had they, in coming to this finding, the Court of Appeal distinguished it from a decision of Carver and the Law Society, in which the Law Society or the officers of the Legal Services Commissioner takes a very different role because they are in essence the prosecutor rather than somebody undertaking an investigatory role. The Court of Appeal emphasised that if at that initial stage the delegates had taken a very firm view one way or another, then they would have offended the interest rule and the outcome would have been very different. For those who are minded to read it, there is an excellent, Justice Brereton gives an excellent summary of the position. The key takeaway points, I think, are firstly that where enabling legislation provides a protective function to an investigatory body and they have a positive duty to investigate it, the powers that those bodies have are significant, and it's basically a matter of complying or finding yourself in a similar position to Dr. Kirby. Secondly, when considering a question of whether there is apprehended bias, and this would come in the context of a number of disciplinary contexts rather than just for naughty dentists, you have to be very clear about the nature of the role of the first instance decision maker against whom it is said that there is apprehended bias. And in doing so, you have to identify and spell out in clear terms what you say it is that will make the decision maker decide the case other than on legal and factual merits. In other words, it's similar to a pleading. You must put the particulars in terms that the tribunal can understand. And there must be a clear and precise articulation of the logical connection between the interests and the feared deviation from the course of deciding the case on its merits. If anyone's got any questions, I'll be able to field some at the end. Sorry, I've run over time.
That's all right, Sam. We'll forgive you. Thank you. Our next speaker is Adrian Maroya with the fascinating title, Proof in the Law of Evidence. But let's not forget that that is at the very heart of everything that we as solicitors and barristers do in any contested matter. So we can't underestimate it. Over to you, Adrian.
Thank you very much, Michelle, and thank you, Sam, and thank you, Dean. I had chosen as a title for my presentation the probably mind-numbing and daunting sounding title, Aspects of Proof in the Law of Evidence. I've revised this presentation down for reasons of time and sanity to an aspect of proof in the law of evidence. So here goes. Recently, while preparing a case for hearing in the district court that involved a residential landlord's duty of care in tort to their former tenant, I had occasion to look at the decision of the Court of Appeal in Stannis and Graham, which was decided in 1994 and is reported in the Australian Torts Reports. The significance of that case for residential landlords is briefly that it made clear some 6 years before the High Court's decision in Jones and Bartlett in 2000 that an occupier of a residential property does not have a duty to inspect the premises for the purpose of discovering latent or unsuspected defects. The facts in Stannis and Graham weren't particularly complicated, but in as short compass as I can put them now, they were basically these. The plaintiff, Mrs. Stannis, was renting holiday premises on the south coast of New South Wales when, in the course of ascending a flight of concrete steps that gave access to the unit that she'd rented, she fell on the top step and was injured. The evidence as found by the trial judge was that when the plaintiff trod on the top step, it moved slightly underfoot and caused her to lose her balance and to fall. Mr. Walsh, who was the caretaker, called by Mrs. Graham, the defendant landlady, gave evidence that he thought that the 4 steps formed an integrated block of concrete. There was, however, other evidence in the case which the trial judge accepted, that the top step was a separate block of concrete from the other steps and was therefore capable of independent movement. A further and important aspect of the trial judge's findings of fact was that when the plaintiff's husband inspected the top step the day after the accident, the plaintiff's husband was able to perceive a slight movement in that step. That issue was an issue that became relevant for reasons which will become obvious in a moment to the state of the landlady's knowledge of this defect. The plaintiff succeeded at trial, but unfortunately for her, had her verdict reversed in the Court of Appeal. One matter that occupied considerable prominence at the hearing in the Court of Appeal was, first, the significance that could be attached to the finding that on the inspection by the plaintiff's husband on the day after the accident, the top step was felt slightly to move, and second, what factual inference could be drawn from that evidence. Now, on this particular aspect of things, Justice Handley, with whom Justices Priestley and Marr agreed in separate judgments, held this, and I quote from Justice Handley's reasons. This finding, namely that the top step was in fact a separate block of concrete, and the finding that the step moved the next day when inspected by the plaintiff's husband, do not establish that the step had moved before the accident and that Mr. Walsh, the caretaker, was aware of this. See Steinberg and Federal Commissioner of Taxation, 1975, 134 Commonwealth Law Reports. Indeed, Mr. Walsh was not cross-examined to suggest that he knew that the step had moved before the accident. The defendant did not give evidence, but in the circumstances, that cannot assist the plaintiff. The result was, therefore, that the Court of Appeal concluded that there was no evidence that the step had moved before the accident, or that the defendant or the caretaker knew that the step had so moved. It was Justice Handley's citation of Steinberg and the Federal Commissioner of Taxation that caused me then to go and have a look and to examine what was said in that case. It's not necessary for the purposes of our brief outline of this issue today for me to refer to the bewilderingly complex facts of Steinberg and the Federal Commissioner. It will suffice, I think, to say that at page 684 of the report, Chief Justice Barwick said, "But disbelief does not afford evidence of the contrary of what is disbelieved." And Justice Gibbs said at 694, "The fact that a witness is disbelieved does not prove the opposite of what he asserted. It has sometimes been said that where the story of a witness is disbelieved, the result is simply that there is no evidence on that subject. But although this is true in many cases, it is not correct as a universal proposition. There may be circumstances in which an inference can be drawn from the fact that a witness has told a full story." And the judge, Justice Gibbs, went on to spell out a number of examples which have particular relevance to the criminal law. Justice Gibbs cited a well-known statement by Lord Justice Scrutton in a case decided in the English Court of Appeal in 1929 called Hobbs and C.T. Tinling & Co., which was to this effect: "If by cross-examination to credit you prove that a man's oath cannot be relied on, and he has sworn he did not go to Rome on May 1, you do not therefore prove that he did go to Rome on May 1. There is simply no evidence on that subject." Part of the underlying significance, I think, of all this state of affairs lies in the important distinction between cross-examination as to the issue and cross-examination solely on credit. In the case of cross-examination solely on credit, the cross-examiner is bound by the witness's answer, and the only inference that a tribunal of fact is entitled to draw is whether the witness is to be believed on his or her oath. In Stannis and Graham, however, it seems to me that a possibly wider principle seems to have been laid down. It must be recalled that Mr. Walsh, the caretaker, was not disbelieved, only that the trial judge found, on the basis of other available evidence, that the top step was in fact a separate concrete block, and that the judge accepted the plaintiff's husband's evidence that, on his inspection the day after his wife's accident, the top step moved slightly. It was held in the Court of Appeal that these findings could not, by a necessarily retrospective inference, furnish evidence that the step had moved before and that such movement should have been noticed by the landlady. In Broken Hill Company Limited and War, 1988 in the Court of Appeal, Justice Clark observed that mere inability to accept the evidence because, for instance, the judge doubted the accuracy of the witness's recall or thought that he may have been confused could not, in my opinion, provide the foundation for a positive finding that the contrary was true. Now, to the extent that positive disbelief of a witness is not required to enliven the principle, Justice Clark's observation goes some way to explaining Justice Handley's statement in Stannis and Graham. But the Broken Hill case wasn't cited by Justice Handley. All of this is, I suggest, not really an instance of the disbelief of a witness principle in cases like Steinberg and the Federal Commissioner of Taxation, but is an application of the wider or larger no evidence principle. That point, I think, appears to be supportable from Justice Gibbs' observation at page 694 in Steinberg and the Federal Commissioner, and Lord Justice Scrutton's statement in Hobbs and C.T. Tinling and Co., upon which Justice Gibbs based part of his observation in Steinberg. In Costas and HIA Insurance Services Pty Limited in 2010 in the High Court, the Chief Justice French observed that a decision which is based on no information at all, or is based on findings of fact which are not open on information before the tribunal, is not compatible with a rational process. And that appears to be what truly underlay the reasoning as to retrospective proof of anterior events in the case of Stannis and Graham. This principle, while I think it will often, if not certainly sometimes, be elusive in its application to the facts of a given case, is an important one. If one is acting for a landlord defendant, it is important to ensure that proper care and scrutiny is imposed on fact-finding, including the drawing of inferences. That has clear implications, as it did for the landlady in Stannis and Graham, for critical findings as to a landlord's state of knowledge or defects and its relationship to the discharge of the landlord's duty of care will be decisive in whether or not a court decides to impose liability on that party. Conversely, it's in everyone's interest, obviously enough, to ensure that first instance fact-finding is properly carried out and that decisions are not made without a sound factual basis. If that is not done, an appeal to a higher court will often prove to be the next and sadly costly step. So there you have it. That's my aspect of proof in the law of evidence for this afternoon's purposes. I had a few other ideas of similar points in mind, and I'm happy, Michelle, if that is the case, to be able to say something about those in the future.
Terrific. Well, thank you, Adrian. A really broad application, I think, across all sorts of subject areas, and obviously critically important to ultimately proving a client's case. We might take this up as an ongoing series, I think. I'll talk to you later. Our
Thank you.
next speaker is Giles Stapleton. Giles, again, a member of 9 Selborne, has a very broad practice area and appears in most of the, if not all of the superior courts in New South Wales. He's put together an update on the responses of the courts, including the courts that we all appear in, to the COVID-19 restrictions. Welcome, Giles.
Thank you, Michelle. I'm just hoping I can load this presentation up. Can everybody see that? I'm assuming everybody can see that. I'm assuming...
I've got it, Giles. It's fine. It's come up for me.
Excellent. I'm assuming everybody can hear me, so I will carry on. Folks, this is a presentation that I've prepared, which is effectively extracting as much or as little material as possible from a very detailed daily update that barristers get from the Bar Association that is intended to give us all a really simple overview of what's going on in what court and how effectively to manage the practice within that particular court and within a particular case in a particular list. So I don't intend to go through it in a lot of detail, but I just want to let you know, sorry, I'm trying to, there you go. The Bar Association has assisted us all by explaining in this regular update what's going on in the Supreme Court, the Federal Court, the Family and the Federal Court in both General and Family Divisions, the LEC, District Court, Local Court and NCAT. So it's extremely useful. The presentation that I've done is available if anybody would like it. You only just have to ask it by email or me. In relation to most of the courts, in particular the Supreme Court, there are currently none or no personal appearances going on except by telephone or by video, or unless there are exceptional circumstances and the Chief Justice or the head of the jurisdiction has granted a concession. Where there are future matters and future listings that we are looking at in the future, then there will be contact by the associate with sufficient time for us all to plan about whether we're going to be doing it by telephone or by video. And a lot of the anecdotes I've heard have been that barristers will commonly go to a solicitor's office where there is enough space in a boardroom and the parties will assemble there with the appropriate amount of social distancing within a small office and appear together, as opposed to solicitor and barrister from the same team appearing separately from different rooms. The normal etiquette of robing and other court protocols will apply according to the list and according to whether it's interim or final. Justice Ward was in a, we at the bar received a copy of a written interview that occurred between a female silk and Chief Justice Ward last week. And Justice Ward was talking very much about how, in effect, the way in which we've all had to work has been relatively successful and perhaps not as scary or as unfortunate as everybody thought it might be. But Her Honour did also indicate, I think personally, that she very much prefers the actual experience of barristers and solicitors being in the same court with her and the dialogue face-to-face as opposed to over the video or over telephone. She also spoke very much about the difficulties if someone does not, well, if somebody puts their phone on mute or on hold while there is an active courtroom with a telephone conference, because what can happen, and this has happened to me where I've been listening to this, unfortunately not doing it, has been somebody has put the phone on mute or on hold and music in the style of a garden centre or a nursing home comes over the telephone line and you cannot hear the judge, you cannot hear the court officer, you cannot hear anybody. And it's highly embarrassing and highly awkward. So Her Honour has made an observation that's to be avoided, but also there seems to be an occasional hazard of receiving more typically at the moment, written judgments from an associate to all of the parties. And obviously that occurs more now than it would because we would turn up to court to get the judgment. And certain people have obviously done or pressed reply all in response to an email from the judge's associate and made various comments to either their own side or accidentally to someone privately, and it's actually been reply all email, and the judge has quickly found out exactly what that particular party's response to his or her honest judgment has been. So that's definitely another tip to be avoided if possible. Do not press reply all in relation to a judgment. In relation to the Supreme Court, the normal Friday list of the commercial list and the technology, construction and commercial lists has gone online as well. It's not conducted in open court. And the probate and the family provision list has been amalgamated into the succession list. And Justice Hallam has been conducting that, I understand, mainly by telephone, but occasionally by video as well. And almost in all cases, the registrar's lists are conducted on the online court by telephone link or by video link, and I've been a number of those. And as I was talking to somebody this morning, a senior Silk, who has done, I believe, 2 5-day cases in the Supreme Court by video link, the comment was that it's nowhere near as bad as you think it's going to be, but it's certainly not as good as you would like it to be. So even though the technology is generally fine now, most people are certainly, at least, you know, most people I speak to very much looking forward to getting back to normal and being able to walk to court and be in court and do what we're all used to doing. The electronic delivery of documents and court and mediations and trials, the explanation here on this presentation of what's going on there is all available. In the federal court, it's similar in that all court listings and events that would otherwise be in person have all been rearranged so that there is now no in-person attendance, and where possible, all hearings are conducted on the papers or by telephone or by video. I recently had a colleague who was very keen to make sure that something was only done on papers, and actually, whilst that was very tempting, because obviously it's a little bit more awkward to appear by video, personally it's still much more appealing to actually appear by video and have at least some connection with the judge about the issue that you would like the judge to consider, and I still think that that's eminently preferable. The family court has got its own set of principles, but not significantly different. They, in fact, have made one particular introduction, which is that for COVID-19 issues arising out of family law disputes, there is a new COVID list, and that really is a bit of a duty list. It's more focusing on urgent matters where there is a serious contest, and it's directly as a result of COVID issues. And I understand that tends to be where there might be a member of a family, for example, making a particular choice about compliance with a court order based on a belief about what the New South Wales or another state's law is about meeting or travelling. Just flipping through this. So that this page is about that COVID-19 list. So this document is really a summary of what we would get, and that provides as much information as anybody would want about the use, for example, of the filing of affidavits and the swearing remotely of affidavits, how to file documents, how to deal with the registrar. And I'm sure by now most of us, if not all of us, have all been involved in one form or another of a video conference or a telephone call. And anecdotally, it does seem to be at least far better for all of us than doing absolutely nothing, which would be very bad news indeed for everybody, including the clients mainly. Jury trials are beginning again in the district court, and the district court chief justice is doing everything possible, especially where there are defendants in custody, to make sure that there's no undue delays in the way those particular people are being dealt with. So that's a nice summary there. And also local court is functioning normally, and so is NCAT, in the sense of people having the opportunity to appear, but obviously not in person. Now, that's all I'm going to say really about presentation. there's a few things that I've noticed actually in the last week. Justice my parent was in the Australian Financial Review on Friday. The heading of his particular article was Video Justice, 10 years of progress for courts in 8 weeks. What Justice Perrin was saying really was that as much as we may have all been dragged to the point of having to adapt, the extent to which we have all adapted in the last 2 months is really the type of adjustment that would have otherwise taken 10 years if none of us were forced to do this. So that I think should be treated as a compliment to the profession generally, all of us. We've all adapted very quickly. Mark Speakman, I also read in an interview, I think last week, was saying something about the fact that litigation may be or may have changed permanently. He didn't say precisely how, but he was indicating that access to justice may be a little cheaper and quicker and easier if we all do, or if we are volunteering to contribute by appearing by phone or video. That was a bit concerning the way that first came out as a practitioner, but Mark Speakman also said in the same article that he felt that as much as the profession can be perceived by consumers and the public to perhaps be a bit stuffy and a bit slow and a bit, shall we say, out of fashion, we are actually well ahead in terms of our ability to adapt to technology. So that was really positive. And my observation is we've all done the best we can, but notwithstanding that, the sooner we're all back to normal, the better. So that's all I have to say, Michelle.
Thank you, Giles. Giles, can I ask you to take the document off the screen?
You can. I hope that's it. Yep.
There we go. That's worked. That's done it for me. Well, fascinating. I especially like the technological tips. Always useful. And I presently have 2 schnauzers and a cat howling for their dinner just down the hall. And behind the white curtains behind me, I've got the washing hanging out. So even in a scheduled standard thing like this, there are things that are sent to try us. I'm sure many others participating have had children screaming and jumping up and down and wanting lunch or attention. Giles, is there any indication yet on when the Superior Court will receive us again into their courtroom?
I'm not personally aware of any. My only observation is entirely anecdotal. I've been a little bit of a rebel and turned up to chambers every day for the last 2 months and got my coffee from the same location, and that location happens to be where many of the Supreme Court judges have got their coffee, and all I know is that many of them are quite eager for it all to return to normal as soon as possible. So I'm pretty sure that they will be saying whatever they can, and everybody will be doing their best to get back to normal. And one objective fact is obviously in a courtroom, if the courtroom is large enough, then there's enough distance between the bench and the bar table, and there can be enough distance between barrister and or solicitor at the bar table. So hopefully those are the sorts of things that will allow us to get back to normal as soon as possible.
One of the good things about the restrictions of in-person appearances is that it is much harder to tug on senior counsel's gown these days than it was before, for which I'm quite grateful, but I think I'd give up that indulgence in order to be back in a real courtroom. Can I ask if we have any questions from our attendees? If you do, perhaps you pop your video on and speak, and you should come up. No, well, we've been so comprehensive that we've left nothing to chance. Can I, you know, we're almost out of time in any event. So can I take this opportunity to thank you for attending and to thank all of our speakers for thoughtful, timely, interesting presentations. We plan on doing this every couple of weeks. So we will continue to send out what I hope are useful and interesting lists of topics The idea is to keep them short and so we can cover a bit of ground. I should say that there've been a couple of references to some documents, and I'm not sure what our protocol is. I am quite confident that Giles will be prepared to share the text of the PowerPoint that he gave us earlier today, and all you need to do is either ask Giles directly or ask our clerk, Ed Brown. You'll find his details on our website if you don't already know. And again, if you have any topics that you'd like covered, either in more detail or in this short 10-minute format, do please send any of us a line and we'll see what we can do. Thank you all for your attendance. Bye-bye.